The US Olympic and Paralympic Committee is suing Logan Paul. Well, technically, they're suing his Prime hydration for blatant trademark infringement. According to a complaint filed in federal court on July 19, 2024, Prime's partnership with basketball star Kevin Durant featured labeling on Prime bottles and advertising all over the place that used the terms Olympic, Olympian, Team USA, and going for the gold. The problem for Logan is these are all registered trademarks owned by the US Olympic and Paralympic Committee, or USOPC for short. So in this video, we're going to go into what's really going on here, why this is a big blunder by Prime, and why Prime is almost definitely going to need to fork over some serious good cash to the USOPC. And in the end, I want to know what you think. Let's get into it. So if you're not familiar, Prime is a sports drink brand started by Logan Paul and KSI in 2022. As a result of their marketing and collaboration efforts over the last couple of years, the brand is now estimated by some to be worth billions of dollars and is in direct competition with other brands owned by Coca-Cola and Pepsi. Meanwhile, there's the USOPC. The USOPC is a federally chartered corporation responsible for the training and funding of the US teams for the Olympic, Paralympic, Youth Olympic, Pan American, and Parapan American Games. Now, although they are federally chartered, the US government does not provide any funding to the US Olympic Committee. According to this complaint, they actually rely significantly on licensing of its trademarks for funding and for its associated funding for the US Olympic team. And they do this all under the Ted Stevens Olympic and Amateur Sports Act. Under this act, Congress granted the USOPC exclusive trademark licensing rights. So if you've ever wondered how Team USA is able to afford the massive quantity of snazzy uniforms, sports equipment, the housing for athletes, the food, the training, the medical care, you name it, this is how. It's the USOPC's ability to trademark and license out their trademarks for advertising. And so when they license their trademarks out to, say, Coca-Cola for being a big-time sponsor of the US Olympic team, know that this is a big money transaction between these two entities. So before we get even deeper into this story, let's pause really quickly to explain trademarks and licensing and what exactly the USOPC owns here. Most people have some idea of what a trademark is, and they usually think of something like logos. Maybe images come to mind like the Nike swoosh or Apple's Apple or the McDonald's Golden Arches. But actually, trademarks are really so much more than that. In fact, the easiest way to understand trademarks is that they're basically any kind of shorthand reference that allows a consumer to mentally link a product back to the source, the company that made it. For example, there are so many different things that can be trademarked. I already mentioned the most obvious one, which is logos. But words and phrases can also be trademarked. For example, Disney owns the phrase Hakuna Matata, and Nintendo owns the phrase "It's on like Donkey Kong." And finally, there's even Mr. T's "I Pity the Fool." Going even further, some colors have even been trademarked. For example, there's Tiffany Blue, and there's the University of Texas's Burnt Orange. And you might even be surprised to know that even sounds can be trademarked. Probably my favorite example is this one. Yep, Darth Vader's breathing is trademarked, and as you can imagine, it is owned by the mouse. But then there's also the more complicated side of trademarks called trade dress, where it's the look and feel of a packaging like a Coca-Cola bottle, or the theme of a restaurant or a storefront that can also be trademarked, like Hard Rock Cafe, for example. Now, I may be aging myself a little bit here, but do you remember back in the day when you'd be walking through the mall and suddenly your nostrils get assaulted by a thick cloud of perfume? And without even looking up, you know that this was because you were passing by Abercrombie & Fitch or maybe their sibling company, Hollister. Yes, that is another example of trade dress. And basically the guiding principle for all of this is that it's consumer driven. What I mean by that is that while trademarks fall under intellectual property law, at the heart of trademark law is an aim to protect consumers. Now that might seem counterintuitive because you never see consumers suing over trademarks. It's always businesses, but hear me out for a second. If you think about it, the existence of trademarks allows consumers to pick up a product in the store and purchase it with confidence that that product comes from the company that you think it comes comes from. And this is important, for example, because if something goes wrong with that product, consumers know where to go to essentially make things right. So for example, if you buy a tube of toothpaste that says Crest on it, you as the consumer don't have to dedicate any amount of resources to figuring out where this product actually comes from. As the consumer, the Crest labeling, that trademark, gives you the confidence to be able to assume that if that toothpaste turns out to be made of material that's going to, say, decay your teeth as opposed to clean and protect them, you know who's at fault and you know where to go. And it's not just about whether this product is going to help or hurt the consumer either. There are all kinds of reasons why people will buy certain products from certain brands. Sometimes it's because the consumer likes that the company holds certain standards or certain values. For example, a lot of people out there buy from Patagonia, not just for the quality of the clothing, but also because Patagonia tries to live by a core value of sustainability. Other times, a consumer's choice might be driven by knowledge of who might be profiting ultimately by that sale. Full disclosure, this is one reason that I really have never had an interest in trying Prime myself when presented with an opportunity to do so. But anyway, that is a basic explanation of trademarks. Now let's talk about licensing really quickly. When someone owns a piece of intellectual property like trademarks, they also have the ability to license the use of that IP to someone else for a specific purpose. Think of this like a landlord renting out an apartment to a tenant. The landlord agrees to allow the tenant to occupy that space for a period of time, and the tenant agrees to make some kind of payment for rent. Everything gets written into a contract, both sides agree to it, they sign it, bada bing, bada boom, the transaction's complete, thank you so much for your business. So with trademark licensing, the concept is actually really similar. The trademark owner says, I will allow you to use our trademark for a specific purpose and probably for a specific period of time, so long as you pay me X amount for that use. They agree on a price and the conditions for the use, and then they sign a contract and they move forward. This is how you get Nike making official sports jerseys for teams. And it's how you get Disney working with companies that sell iPhone cases of all things. And the thing is, the more exclusive the licensing given to the licensee, generally speaking, the more valuable or costly that license is going to be. So for example, in this case, where the USOPC has granted an exclusive license for its beverages to Coca-Cola for their sponsorship, that exclusivity was bought by Coca-Cola for a ton of money. I don't know how much, but it had to be a massive amount. So imagine you're Coca-Cola and you just paid a significant amount of money to be the exclusive partner with Team USA, and then you see Logan Paul with Prime over here using some of those trademarks for a competing product. From Coca-Cola's perspective, this is essentially like a tenant paying a landlord to live in a really nice apartment, only to walk into the kitchen and see some random dude using the stove to cook some eggs in his tighty-whities. In that situation, the landlord's going to need to be the one to get rid of that random dude and make sure that they don't have a way to come back. And so in a similar way, that's one big reason why the USOPC is suing Prime here. Now, they also are required by their federal charter to do so, as well as by other concepts in trademark law requiring a trademark owner to affirmatively protect their trademarks in court, but we do not need to get into that much detail on that particular issue. The point here is the USOPC and Coca-Cola have entered into an exclusive branding deal, and the burden is on the USOPC to essentially put Prime and Logan Paul to task here. Okay, so that's the basic foundation for what you need to know about trademarks and licensing to understand this whole controversy. So what exactly is Prime doing wrong here? Well, according to the complaint, there are 4 protected marks owned by the USOPC that the USOPC says Prime is using on one of its recent products without permission by the USOPC. This is the Prime bottle showing the collaboration of Prime with basketball star Kevin Durant. Specifically, the USOPC says they improperly used the following words and phrases: Olympic, Olympian, Team USA, and going for the gold. All of these are words and phrases for which the USOPC has long owned the trademarks, which are registered with the USPTO, the United States Trademark and Patent Office. And in the complaint, the USOPC alleges that Prime has used these phrases in a number of ways with these Prime bottles showing their Kevin Durant collection. For one thing, there's the actual labeling on the packaging. You can see here they allege that the label itself refers to Kevin Durant as a 3-time Olympic gold medalist. So you've got the trademarked word Olympic here. Even though it is factual that he is in fact a 3-time Olympic gold medalist, Prime cannot use that term because that is trademarked. Then you can read on where it says, what makes a true Olympian repping Team USA? A 3-point wizard, a master of the mid-range, skill, determination, heart. These are the marks of his game. So here you've got the trademarked word Olympian as well as the term Team USA. And then finally, it says bottles up fam because when KD steps on the court, he's going for the gold. So there you have the trademarked phrase, going for the gold. So already we've got some uses of USOPC's trademarks. But it's not just on the labeling. The complaint also highlights infringing uses on social media like Prime's Instagram, and they show the infringing uses on Prime's website. And what's more, it alleges that Prime provided other vendors for the product with ad copy that further infringed USOPC's trademarks by prominently displaying them on the product advertising. And all of this was up and all over the place despite the USOPC allegedly sending Prime a cease and desist letter telling Prime that Prime was violating USOPC's trademark rights. So they allege Prime isn't just doing this accidentally. Instead, they allege that Prime is being willful and malicious here. Now, looking at this whole situation, you might be a little bit astounded by some aspects of it. Like, can a company really own the rights to a word like Olympic or Olympian? And the short answer to that is yes, 100%. Now, there definitely are some situations where a company might be a little bit too broad in their attempts to own a mark. For example, if the word or phrase is actually something that is just too commonly used, courts might find that there is actually a free speech implication and therefore not allow the plaintiff to protect that as a trademark. As an example, this argument was at the heart of a bitter dispute between Taco Bell and Taco John's over the phrase Taco Tuesday up until July 2023, when Taco John's decided to cancel its trademark registration of the phrase. But this situation with Prime and the USOPC is not like Taco Tuesday. This is more like the Super Bowl. Have you ever noticed how around the end of January or beginning of February, when you see advertising for stuff like tortilla chips and salsa, the ads might hint at the Super Bowl, but never actually say Super Bowl? That's because they legally can't use that phrase unless they officially sponsor the NFL Super Bowl event. So you'll see some ads say something like the big game or the game, and this is all because of trademark licensing. And here, in this case, it's very clear to anyone who's watched the Olympics in the US that Team USA always partners exclusively with brands that sponsor the team. So if you see a Frosted Flakes box with Michael Phelps' face on it and Olympic rings next to his face, you know that this is because of one of those partnerships. And I would actually put good money on the likelihood that there is a certain percentage of consumers who will tend towards buying a certain product around the Olympic Games specifically because it's supporting Team USA. So those marks do have commercial value for these brands that are getting the licenses to use them, of course. And the thing about Prime's use of these marks is that there is totally a likelihood that it will confuse consumers into thinking that Prime actually is a sponsor of Team USA. And that's an important piece in this lawsuit too, by the way. Remember how I said that all trademarks are rooted out of this idea of consumer protection? Well, in any trademark case, one of the main questions that's going to be analyzed is whether the infringing use is likely to confuse consumers. When courts analyze this, they look at a number of factors. One of the big factors is the kind of product that's allegedly infringing the trademark compared against where consumers will typically see that mark. So making that comparison, would the average consumer look at Prime's use of the marks in context and think that they had become one of Team USA's sponsors? Given the fact that food products have been very common placements for Team USA's trademark licenses, I'd say hell yeah, it's likely to confuse consumers. And you know, there are plenty of people and small businesses out there that could totally unknowingly make the mistake that Prime has made here. Not everyone is aware of the breadth of trademarks and how certain words and phrases can't be used for marketing because of these kinds of licensing issues. But Prime is not one of these companies that can claim ignorance. For one thing, like I said, the USOPC apparently sent a cease and desist letter to Prime over this whole thing, and Prime ostensibly ignored it. But even beyond that, generally speaking, Prime 100% understands branding partnerships and the commercial value that they bring to both sides of a partnership. And they also understand exclusive partnerships with sports teams because they've done it themselves multiple times over. After all, Prime itself has become an official sponsor for the Toronto Raptors, the LA Lakers, FC Bayern, Arsenal, and unfortunately also my beloved Dodgers. So all of this is to say that the way I see it, one of two things happened over at Prime to cause this massive blunder. Either one, someone at Prime really messed up by failing to do their research or failing to listen to lawyers advising Prime, or Prime is blatantly violating USOPC's trademark rights to see if they can just get away with it. And if that's the case, law of FAFO is at play here.
See, as you can see, the more you around, the more you're going to find out.
And in the end, I do think that this is a fairly open and shut case benefiting the USOPC. These marks have been owned by the USOPC for a very long time. They're registered with the US Patent and Trademark Office, and they show very clearly that Prime is using these marks to market their product, which is the type of product that consumers might think is actually licensed by Team USA. But those are my thoughts. What do you think? Do you think Prime's usage of these terms and phrases is likely to confuse consumers? Or do you think the USOPC is going too hard over this one? Let us know in the comments down below. Otherwise, I hope you enjoyed this, or at least found it interesting or informative. And if you did, I would love it if you could hit the like button. It does help us with the YouTube algorithm gods. And if you're new here and you want to see more coverage of crazy cases and interesting legal topics, be sure to hit the subscribe button and the notification bell so you can find out when the next video is out. And if you're really loving the content and you want to know how best to support the channel and enjoy perks like early access to videos like this one, consider becoming a member of Byte Club. You can join either through YouTube memberships or by becoming a supporter on Patreon. Links to both are in the description below. Otherwise, see you in the next one.